Welcome to Public Health on Call, a podcast from the Johns Hopkins Bloomberg School of Public Health, where we bring evidence, experience, and perspective to make sense of today's leading health challenges. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes.
This is Lindsay Smith-Rogers. Today, the Supreme Court of Alabama rules that frozen embryos are children. Joanne Rosen is a lawyer who studies reproductive health and a practice professor at the Johns Hopkins Bloomberg School of Public Health. She joins Dr. Sharfstein to talk about the case that led to this ruling and what it means for IVF treatment and beyond. Let's listen.
Joanne Rosen, thank you for returning to Public Health on Call. Today we're going to talk about this court case in Alabama. Can you tell me about it?
Sure. It was released just last Friday, February 16th. I'll start with the facts, if that's okay with you. That's where I always start with my students. What are the facts of the case? And these are pretty bizarre facts. So the plaintiffs in this case are three couples who all underwent IVF treatment at this fertility clinic in Alabama. And through the IVF treatment that they received, they were all actually able to become pregnant, and they gave birth, quite fortunately, to healthy babies. But they also, as a result of the IVF treatments, produced a number of additional embryos. And this is quite common. It's actually standard procedure in an IVF cycle. And those additional embryos that were not used as part of the IVF cycles were then frozen, and they are preserved or banked by the fertility clinic. And the presumption is that the couples could come back at some later time and have another IVF cycle and use these embryos without having to go through the fairly arduous hormonal treatment and surgeries involved. And then this next part is where it gets bizarre and what gave rise to this case. So the plaintiff couple's frozen embryos had been cryopreserved and banked. The fertility clinic is located within a hospital. At some point in December of 2020, some patient of that hospital made their way to the fertility clinic's cryopreservation unit within the hospital, entered that unit, opened one of the tanks in which frozen embryos are stored. They are stored at sub-zero temperatures, sub-freezing temperatures. This patient put his hand in, grabbed some of the embryos, burnt himself, dropped the embryos, they hit the ground, and they were destroyed. The plaintiff couples brought lawsuits against the fertility clinic and the hospital. One of the lawsuits is for negligence and wantonness, but that wasn't what was dealt with. The other lawsuit, and the one that's the subject of this case, was against the hospital and the clinic for the Wrongful Death of a Minor Act, which is an Alabama statute. At the trial court, this case was dismissed because the trial judge said that embryos that exist in vitro are not people or children for the purposes of the Wrongful Death of a Minor Act, and therefore there was no claim that the couples could bring under that act. And the couples then appealed that decision to the Supreme Court of Alabama, the highest court in Alabama. And the Supreme Court disagreed and, in a nutshell, said that the Wrongful Death of a Minor Act applies, this is a brief quote, to all unborn children without limitation. And that includes unborn children who are not located in utero at the time they are killed. So, in effect, the Alabama Supreme Court determined that these in vitro embryos are persons, declared personhood. So they are children or people. And the couples then can proceed with their lawsuit, and they are seeking punitive damages for, in their case, what they say is the wrongful death of their children.
Wow. So just so I understand, the district court said, look, this embryo was in a freezer. It can't be considered a child. It is not in utero. But the Supreme Court said actually it can be considered a child, and it is a child, essentially.
Yes, that's exactly right. The Wrongful Death of a Minor Act dates back to 1872. Clearly, at the time that it was introduced, there was no existence of IVF, and in fact, even a very different understanding of the developing fetus and so on. There is prior Alabama Supreme Court case law making clear that a fetus developing in utero is considered a child for the purposes of wrongful death of a minor act. And so if a fetus developing in utero dies as a result of some incident or accident, a parent could bring a claim under that act. But this is the first time ever the definition of a minor or a child under that statute has been applied to an embryo that exists in a lab, sort of outside of a human uterus.
Now, the consequences of the decision have been pretty quick to evolve. In the last few days, a number of fertility clinics have stopped IVF procedures in Alabama.
That's right. There are, at least from what I've read, there are 2 fertility clinics. One of them is the University of Alabama at Birmingham Health System, so a very large clinic. 2 out of the 8 fertility clinics, as of right now, within the first week, have paused their IVF treatments. And they've said that they did so out of real concern of the civil and potential criminal liability that their physicians and potentially patients might face. And that also involved this week the physicians calling patients who were scheduled to have that last part of the IVF treatment, the transfer of embryos into the uterus, to have those canceled for the time being. So the consequences, as you say, have been really swift.
And the reason they've done that is they're concerned that some embryos may be destroyed in the process of actually pursuing IVF.
That's exactly right. There is a very small possibility that when embryos that have been frozen are thawed and prepared for transfer, they may be damaged or destroyed and therefore unable to be successfully transferred. And that could be the wrongful death of a minor. Even non-frozen, sort of fresh embryos may be damaged and not able to be transferred. So there was real concern about the legal consequences, given that these embryos, these in vitro embryos, have been declared persons under the law in Alabama.
I want to ask about other potential consequences of this decision for people in Alabama. You can go online and people are speculating about all sorts of things. Like, does this affect people's taxes? Does this affect, other requirements? How do you see this question? Are there other major legal consequences that might flow?
So I know there's a lot of speculation. If you've got frozen embryos, can you declare them as dependents for the purposes of your tax return? Those, I think, are kind of pretty remote and pretty far afield. But the more immediate consequences are there is, by at least some count, over 1.5 million embryos that are currently frozen across the US. So this isn't all in Alabama, but it raises a huge question about what the obligations are for these frozen embryos. Does this mean that they cannot be destroyed, that they have to be preserved sort of into perpetuity? About half of all IVF cycles that take place involve pre-implantation genetic testing of the embryos. Many of the couples that seek IVF are doing so because one of the members is a carrier of a known genetic mutation that's associated with a really serious disease or condition. And so they seek IVF so that they can have their embryos genetically tested prior to implantation. And usually, if this genetic mutation is discovered in an embryo, the embryo is discarded. Does that mean that pre-implantation genetic testing should no longer be taking place because you can't discard the embryos? So, those are just 2 of the questions that arise involving what to do with these embryos if they're human beings and can give rise to liability.
Now, you have come on the podcast to talk about some of the cases at the local and state level related to abortion. And I wonder how this connects to those cases from a legal perspective.
So at the time that Dobbs was decided, and even slightly before Dobbs was decided, when it became pretty clear that the Supreme Court was likely to reverse Roe versus Wade, one of the questions that was being talked about and written about by bioethicists and legal scholars, as well as by reproductive technology specialists, was if the Supreme Court reverses Roe and allows states to regulate life from the moment of conception, this could indeed have implications for IVF because IVF creates embryos. And in fact, the Supreme Court in Dobbs actually said that states have a legitimate interest in the preservation and protection of prenatal life at all stages of development. So there was speculation about whether there would be litigation around IVF. Could there be attempts to ban IVF because of concerns for how you are treating embryos? Could there be more aggressive attempts to regulate IVF? Interestingly, in Alabama, right, where all of this occurred, Alabama introduced their abortion ban in 2019 before Dobbs, and it wasn't allowed to go into force because it was unconstitutional at the time. Now it is in force. But interestingly, the abortion ban in Alabama defines abortion as a procedure that causes the death of an unborn child in utero at any stage of viability. So a full ban on abortion at all stages of viability, but they specifically said in utero. And when that bill was introduced in the Alabama Senate, the senator who was the sponsor said that they'd used the words in utero deliberately because they wanted to make clear it was not their intention to interfere with IVF. That doesn't mean that Alabama won't act differently after this decision, but I think it reflects an understanding that IVF matters deeply to many people, and it's a procedure that's used to create life, to create pregnancy. So it is a pro-life medical technology. So the political headwinds around IVF are kind of complicated.
Yeah, there does seem to be a bit of an irony that the movement, or at least the legal movement that has opposed abortion, has kind of landed in a place that may prevent a lot of pregnancies.
Yes, absolutely. Again, the sort of pro-life, anti-abortion movement may find that it collides in a way with itself. Abortion terminates pregnancy, and IVF exists to create pregnancy.
So how do you see this playing out? This is not the kind of decision that gets appealed to the federal courts, correct?
I think that's correct. There isn't, at least to my mind, a clear path to take this case to the Supreme Court, the US Supreme Court. It involves an Alabama state statute. It involves an interpretation of the Alabama state constitution. I think that the ball is more likely to land squarely in the court of the Alabama legislature. And so there were 9 justices that heard this appeal in Alabama. They're called justices on that court. 2 of them, one in dissent and one who agreed but wrote separately, both of them have said that the proper body to determine how to regulate IVF and what to do with embryos, that proper body isn't the court, but it's the legislature. So I think that this issue is likely to land back in the Alabama legislature, and they will have to decide what to do, whether, in fact, they want to carve out a particular kind of exception for wrongful death statutes that would not introduce all this complication for in vitro embryos, whether they want to take a more wide-ranging look at IVF and bring in bioethicists and reproductive endocrinologists and legal scholars, look at the legal and bioethical issues more broadly. But I think this will become an issue that the Alabama legislature will address in some way.
Well, I'll tell you, Whether or not they bring in those experts, my intuition is that parents of children conceive with IVF, and parents who will need IVF to conceive children will probably not be very quiet in those kinds of proceedings.
And that is, I agree with you, and that is as it should be, right? Dobbs did say, although we're not talking about laws to ban abortion here, but the Dobbs court did say that issues of abortion regulation should be returned to the people through their elected lawmakers. This isn't an abortion case, but the debate around how to manage something in which people have so much deep investment should involve voices across the spectrum. I would be remiss, Josh, if I didn't just take us back to part of what makes the Alabama decision so extraordinary. I mean, clearly extraordinary in its determination that in vitro 8-cell microscopic embryos are considered people. But it was the decision of the Chief Justice, the concurring decision, and of the main justice are really redolent of theological kind of discussion. And as I was reading these opinions, what really struck me is the rhetoric sounds more like scripture than it does the language of the law. And if you will bear with me, I can sort of read you one little piece so that listeners have a sense of what this decision actually says.
Please.
So this is from the Chief Justice of the Alabama Supreme Court. And he says, this is a quote, "We believe that each human being from the moment of conception is made in the image of God, created by him to reflect his likeness. It is as if the people of Alabama took what was spoken of the prophet Jeremiah and applied it to every unborn person in the state." And the Chief Justice continues, "Carving out an exception for the people in this case," he's referring to the embryos, "small as they were, would be unacceptable to the people of this state who have required us to treat every human being in accordance with the fear of a holy God who made them in his image." So that is part of why this has been such a remarkable decision, both in outcome, but also in the analysis that took us to that outcome.
Well, that adds a lot to understanding what's going on, and I think makes it even more important that we watch very carefully to see what happens in Alabama, including in the Alabama legislature. Thank you so much, Joanne Rosen, for joining us on such short notice to talk about this case.
You're welcome, Josh.
Public Health on Call is a podcast from the Johns Hopkins Bloomberg School of Public Health, produced by Joshua Sharfstein, Lindsay Smith-Rogers, Stephanie Desmond, and Grace Ciceri. Audio production by J.B. Arbogast, Holly Cardinale, Spencer Greer, Matthew Martin, and Philip Porter, with support from Chip Hickey. Distribution by Nick Moran. Production support from Catherine Ricardo. Social media run by Grace Ciceri and Eliza Rosen. If you have questions or ideas for us, please send an email to publichealthquestion@jhu.edu. That's publichealthquestion@jhu.edu for future podcast episodes. Thank you for listening.